So according to the court, 53 candidates granted high marks in Viva VOC.
For that, the entire
The entire process should go. That is the approach of the court.
Yes.
Then please take me, Lord, paragraph number 17, where I only draw your Lordship's attention to the corruption aspect part. From the gross illegality in the selection procedure in the recruitment exercise of so-and-so conducted by the board, we're pausing here for a moment, Millard. There was no allegation of corruption in 2016. I've taken your Lordship through the pleadings. Whatever corruption alleged, right, wrong, TET 2014. It is clear that the board and its officials, including its former president, who is now in custody after arrest by the Enforcement Directorate for transaction of huge money in the recruitment procedure, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs for primary school teachers were actually sold to some candidates who had the money to purchase the employment. A corruption of this magnitude was never known to the state of West Bengal. The former minister, former president, and a number of middlemen through whom jobs were sold like commodity are now behind the bars, and the CBI ED investigation is being continued in full swing. This paragraph. It can come in this paragraph provided the judge is examined as a witness. 1871 Indian Appeals Made, I'm going to place.
Yes.
How can the court import its personal knowledge in the matter? Which CBI, which ED, which investigation? Where are those documents in the records of this proceeding?
Did you argue this in the appeal which was preferred against this order, interim order appeal? So this personal knowledge of the single judge was not argued, which you are.
No, that was interim order, Miller.
Yes,
this is the final one.
Judgment of Justice Subroto Talukdar.
Yeah, that was at the interim order stage.
Yes, yes. That ground was not taken by you.
Miller, this is a point of law, Miller. I can take it even in a collateral proceeding, Miller. Even in a collateral proceeding, Miller, I can take it.
Yes, next.
Then kindly take paragraph 18. It is a matter to be noted that the board in its affidavit in opposition while dealing with all pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above sense of law. If the writ application is thrown out on such niceties of law, as this will appear that in the name of preserving the law, the corruption would be protected, which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience.
Yes, yes. You have placed this, Mr. Not placed this.
So constitutional conscience, I must say that in this recruitment scam, stinking rats are being smelled. The board placed some judgments before me in support of the niceties of legal principles, which I do not find have any applicability in the fact of the magnitude of stinking corruption in the recruitment exercise of 2016 conducted by the board. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars of the space, much above the ground realities.
So you now want us to deal with your judgments?
No. The
The judgments which we have cited
yes,
before the learned single judge, that were
with
not,
respect, my lord, it is not even noted.
it was not.
If somebody tells me that no, you have not cited this judgment, I can't say anything.
Yes.
But
No,
the minimum that I can expect is
no, that is
the
why
judge
we
will at
noted.
least note that so and so has submitted the ABCD judgments.
Is
Yes,
it to
but
be
not really.
submitted? Mr. Dotto, Advocate General, argues it is to be submitted.
Yes. Then last paragraph, kindly take note, para 25.
Yes.
This whole imbroglio, including corruption involved in the matter, has taken place due to the former president of the board who knew the rules of recruitment but violated the rules, and therefore, if the government thinks the entire expense for holding of the recruitment exercise can be realized from the estate of such and such. So the corruption is infraction of the rules. Para 25 is very important. Finding is corruption based on infraction of rule.
Yes.
But now,
Yes.
infraction of a rule can be an irregularity, can be a lapse, can be a departure, but it cannot be corruption. Now, what is corruption? And I'll place judgments on that. But simply saying corruption, corruption, corruption does not make it a corruption. A judgment of record. 7 7 আর 4 9. But please take my lord Black's Law Dictionary, 10th edition. At the second page, my lord, page 421, please take the right hand side column at the bottom. But the meaning of corrupt is said to change someone's behavior, morals, or principles from good to bad, to pervert the integrity of, to change the traditional and established form of culture, language, etc., so that it becomes worse than what it was before, to destroy or diminish the quality and usefulness of an electronic or mechanical device or its component, archaic, to impose corruption of blood on a person. Now, what is corruption? Kindly turn the page. The left hand side top.
Page.
With the next page, page 422. এই ভুল আছে নাকি? 20 বললাম?
Which page?
There are two pages, 421 and 422.
Oh, you put my copy 21 given at the bottom. Yes.
Oh, I'm so sorry. I'm sorry.
Yes, corrupt.
But
No, it's okay. It's okay. Yes.
now please take note 422.
Yes.
Corruption is defined as depravity, perversion, or taint, and impairment of integrity, virtue, or moral principle, especially the impairment of a public official's duties by bribery. The word corruption indicates impurity or debasement, and when found in the criminal law, it means depravity or gross impropriety. Then two is a fiduciary's or official's use of a station or office to procure some benefit either personally or for someone else, contrary to the rights of others, an act carried out with the intent of giving some advantage inconsistent with the official duties or rights of others. This is, Millard, the traditional definition of corruption.
Yes.
The important or the relevant part over here in our case is impairment of public officials' duties by bribery. First is, Millard, here we do not have any identified public official. You cannot just say given money, taken money, sold job, given jobs to the less meritorious in a case of corruption. It has to be Mr. X found. First of all, Millard, this is not a proceeding in which this can be gone into. Be that as it may, Millard, fundamentally speaking, Millard, in a case of corruption, a person has to be identified and proved that he has indulged in corruption through bribery, illegal gratification, etc. Now, how, Millard, the expression corruption is being defined in judgments of the Supreme Court? Please take, Millard, 2004. Or first, kindly take 97 seat of 97 seat of উঠে 97 3 আরেকটা দাও পেজ 403 হ্যাঁ kindly first take 1997 volume 3 Supreme Court cases page 483 এই আরেকটা কপি আছে এই আমারই তো নেই না দাদা payment of back wages would provide an impetus and put premium on corruption. The society has to pay the price for corrupt officers for public exchequer. Therefore, when the court directs payment of back wages on reinstatement, the court tribunal is required to consider the backdrop of the circumstances and pragmatically apply the principle to the given set of facts. No abstract principle of universal application could be laid in that behalf. The confidential report of the officer prior to initiation of the prosecution do furnish evidence of conduct of the public official. It is the duty of the officer to place his material and of the government to place all other necessary records in that behalf before the court tribunal consideration, and it would be for the court tribunal to consider and decide the matter. This court has
This is on back wages payment.
yes, this is a back wages case, but Miller, two things are important over here. First, it says that it is an unsatiated greed for wealth, and again, where I am saying where a public official has to be identified,
Yes, sir.
and there has to be exchange of money, illegal gratification demand,
Yes.
and Millard handing over. Kindly take me at the next judgment of 2004-9 Supreme Court cases 319. 2004 Volume 9 Supreme Court cases 319. 319. Kindly take only one paragraph, paragraph 3.
Thank God. Yes.
Corruption as such has reached dangerous heights and dangerous potentialities. The word corruption has a wide connotation and embraces almost all the spheres of our day to day life and world over. In a limited sense, it connotes allowing decisions and actions of a person to be influenced not by rights or wrongs of a cause,
But by the prospects of
but by the prospects of monetary gains or other selfish considerations. Avarice in a common frailty of mankind, and while Robert Walpole's observation that every man has a price may be a little generalized, but it cannot be gainsaid that it is not far from truth. Burke cautioned among a people generally corrupt, liberty cannot last long. Therefore, monetary gains and other selfish consideration is the other expression used by the Supreme Court. But our High Court in 1994, which is very important, I feel, for my case, is that specific instances of corruption has to be highlighted.